Presidential Decree 968 or the Probation Law, Section 1 to 10. Section 1. Title and scope of this decree. This decree shall be known as the Probation Law of 1976. It shall be applied to all offenders except those entitled to the benefits under the provisions of 603 and similar laws. Section 2. Purpose. This decree shall interpreted to us a. Promote the correction and rehabilitation of offender by providing him with individualized treatment. B. Provide an opportunity for the reformation of penitent offender, which might be less probable if he were served a prison sentence. C. Prevent the commission of offenses. Section 3. Meaning of terms. As used in this decree, the following shall, unless the context otherwise requires, be constructed thus: A. Probation. Probation is a disposition under which defendant, after conviction and sentence, is released subject to conditions imposed by the court and to the provisions of probation officer. B. Probationer means a person placed on probation. C. Probation officer means one who investigates for the court a referral for probation or supervises probationer or both. Section 4. Grant of probation. Subject to the provisions of this decree, the court may, after it shall have convicted and sentenced a defendant, and upon application at any time of said defendant, of said sentence, and place the defendant on probation for such period and upon such terms and conditions as it may deem best. Probation may be granted whether the sentence imposes a term of imprisonment or a fine only. An application for probation shall be filed with the trial court with notice to the appellate court if an appeal has been taken from the sentence of conviction. The filing of a application shall deem a waiver of the right to appeal or the automatic withdrawal of pending appeal. An order granting or denying probation shall not be appealed. Section 5. Post-sentence investigation. No person shall place on probation except upon prior investigation by the probation officer. a dirty and a determination by the court that ends of justice and best interests of the public as well as the defendant will be served thereby. Section 6. Form of investigation report. The investigation report to be submitted by the officer under Section 5 hereof shall be in the form prescribed by the probation administrator and approved by the Secretary of Justice. Section 7. Period for submission of investigation report. The probation officer shall submit to the court investigation report on a defendant not later than 60 days from receipt of the order of said court to conduct investigation. The court shall resolve the petition for probation not later than 5 days after the receipt of the said report. The submission of the investigation report and the resolution of the petition, the temporary liberty under the bail filed in the criminal case, provided that in this case where no bail was filed, that the defendant is incapable of filing one. The is field or the defendant is incapable. The court may allow the release of defendant, of recognize the custody of responsible member of the community, shall guarantee his appearance whenever required by the court. By this court, by a court, by court. Section 8. The criteria for placing an offender on probation. In determining whether an offender may place on probation, the court shall consider all information related to the character, antecedents, environment, and mental and physical condition of the offender. and available institutional and community resources. A. The, the offender is need of correctional treatment that can be provided effectively by commitment of an institution. B. There is undue risk that during the period of time of probation, the offender will commit another crime. C. Probation will depreciate the seriousness of the offense committed. Section 9. Disqualified offenders. A. Sentenced to serve a maximum term of imprisonment of more than 6 years. B. Convicted of any offense against the security of a state of the state. C. The previously been C. Who have previously been convicted by the final judgment of offense punished by imprisonment or not less than 1 month and 1 day, or fine not less than 200 pesos. D. Those who have been once on probation under the provision of this decree and who already serving sentence at the time of some substantive revision of decree became applicable pursuant of section 33 hereof and section 10 conditions of probation. Every probation order issued by the court shall contain a conditions required that the probation shall A. To present himself to the probation officer designated to undertake his supervisions and such place as may supervisions order within 72 hours from receipt of the order, and B. Report to the probation officer at least once a month at such time and place as specific. And that is the Presidential Decree 968, the Probation Law, Section 1 to 10.